You're with Steve Austin on ABC Radio Brisbane.
Well, one of the features of Queensland's Crime and Corruption Commission is that it has what are usually regarded the powers of a standing royal commission. They have the power to compel you to speak, whether you want to or not. It's called the losing of the right to silence. And a prominent civil liberties advocate says the corruption watchdog, that's the CCC, use of the secretive, coercive hearings to force witnesses to give up information is being overused. Terry O'Gorman is the Vice President of the Council for Civil Liberties, and he says people who are called to attend Crime and Corruption Commission Star Chamber hearings can be jailed if they lie or don't cooperate. And Terry O'Gorman says that could deter whistleblowers from willingly coming forward. Terry O'Gorman, how do you know, where is the evidence it would deter whistleblowers from coming forward?
Well, look what happened recently, Steve, to a person who describes himself as a YouTube celebrity who released information about the problem with Queensland rail networks. Now, we've seen the problems about Queensland rail in the news for the last 3 years. What happened? He was called down to one of these Star Chamber hearings to be questioned about where he got his information from. And that's just absurd that an apparent whistleblower like that, who released public information of great interest to people who have to put up with the ongoing delays and problems with Queensland Rail, should be called down to a secretive Star Chamber hearing and made to answer questions under threat of being jailed if he didn't answer questions.
Was that just a one-off, or is this a pattern?
Well, certainly a whistleblower such as him, I'm not aware of any others. But the fact is, you can't be told that someone else in his position has been before a Star Chamber, because if you do, you commit an offence. And indeed, this particular individual, when asked to comment today about this particular scenario by the ABC, said, I can't because I'm before the courts charged with a criminal offence for in fact telling someone I'd been down to the Star Chamber. Now that's the problem. High-level crime, murder, terrorism, okay, but over the period of the last 10 years, figures that have been produced by the ABC today show that these Star Chamber hearings have quadrupled, and I can say as a lawyer, I have seen them move from what was supposed to be the case, namely reserved for top-drawer, very serious cases, to really low-level stuff such as this bloke with Queensland Rail.
Terry O'Gorman is the Vice President of the Council for Civil Liberties. This is ABC Radio Brisbane. Steve Austin is my name. So what sort of case or legal issue would that extraordinary power be reasonable? In what sort of context would it be reasonably used?
Oh, because it's been around for a couple of decades or more, it's reasonable to use it in respect of serious crimes that the police can't otherwise solve, such as murder, such as certain terrorist cases in cases of urgency. But I have seen really low-level stuff over the period of time be dragged before these Star Chamber hearings. And what upsets a number of defence lawyers about it is if you have a client who's brought down there for a really low-level case and you want to complain about it, you commit an offence by even telling you, Steve Austin, or any other journalist, that you've had a client dragged down there for a particular hearing that just should never have been called. When the Star Chamber was set up at the end of the Fitzgerald report and the Fitzgerald inquiry in 1990, at that time, Fitzgerald recommended that before you or I or anyone else can be brought down to a Star Chamber, the CCC should have to go to a Supreme Court judge and get a case-by-case, in effect, warrant or order for it. Over the period of time, that's just been wiped away, and now the police, more and more for low-level stuff, are using these sorts of hearings where if you don't answer questions, you go to jail. If you're charged with perjury and convicted, you go to jail. And a number of police, in cases I've had, have threatened people on what my clients have told me with a charge of perjury and frightened them into a situation of, well, if I'm being threatened with perjury, I really got to say what I think the police want me to say.
But as I understand it, the people are rarely charged with perjury, let alone found guilty in our legal system, aren't they? It's not common.
Oh, no, it is common enough, I can tell you, in relation to people being charged with perjury arising from evidence given in Star Chamber hearings. And the law in the cases are that if you get found guilty of perjury in one of these Star Chamber hearings, you go to jail often for a period of 6 to 12 months. So while it's not every week, it's common enough.
So it's legitimate for unsolved murder cases, organised crime and significant drug matters. But in this case, the Crime and Corruption Commission used it to find out where a guy got a train timetable from.
And that's just outrageous. And Mr McSparron QC would say, oh, don't you worry about that. The Parliamentary Committee will appropriately supervise it. I've appeared before the Parliamentary Committee over a period of years since the Crime and Corruption Commission and its previous names were set up. There's such a turnover on that committee. That committee doesn't carry out an adequate supervisory role over the Crime and Corruption Commission at all.
My guest is Terry O'Gorman, Vice President of the Council for Civil Liberties. He's arguing that the corruption watchdog, the Crime and Corruption Commission's use of their secret coercive hearings is overused and thinks it should be changed. So you want what reform of this extraordinary power? For it only to be used with a Supreme Court judge?
Yes. It is such an extraordinary power and carries extraordinary consequences for people who are charged with not answering questions or perjury that the Fitzgerald recommendation should be implemented. Namely, if the CCC say, well, we want to use this power, they should go to a Supreme Court judge. If the Supreme Court judge says, well, hang on, this power is pretty dramatic, it's pretty draconian, you shouldn't use it for a bloke who's releasing information about Queensland Rail, if that case had gone before a Supreme Court judge, it would have been kicked out over the fence unceremoniously.
My guest is Terry O'Gorman. We did invite the Crime and Corruption Commission Chairman Alan McSparron to join me this evening, but sadly he's unavailable. He does say the organisation is careful how it uses coercive hearings, and he disagrees with critics who say the Star Chamber system deters whistleblowers. Here's a little bit of what he told ABC News.
People who have access to confidential information are under an obligation of trust not to disclose that without very good reason. If there's, for instance, a belief that they want to blow the whistle, as it were, they should come to us confidentially to report the matter and have us investigate. If at the end of the day we decide not to take any action, they think that's a wrong result, that we've dropped the ball or we haven't investigated properly, they can then go to the media. But they shouldn't be going to the media as their first option.
Does that mitigate matters at all or ease your concerns of the Civil Liberties Council, Terry O'Gorman?
No, not at all. The ABC website today carries a story about the bloke with the Queensland Rail Network whistleblowing. What happened? He was pulled down there and now he faces a charge of telling someone he was pulled down there. If I was advising a whistleblower as a lawyer, I'd say, well, if that bloke got this consequence, do you want to risk the same?
There is a parliamentary committee that oversees the work of the Crime and Corruption Commission. If someone can be hauled before the Star Chamber for releasing a train timetable, sorry, I don't mean to laugh, but does that mean that the parliamentary committee is not doing their job?
Well, I think you should laugh because it really is hilarious, even if highly regrettable. Look, the parliamentary committee has a constant change of membership as against an organisation that has a service level, people who've been there for 20 years or more. So a constantly changing parliamentary committee can only do a superficial job of calling the CCC to account, and there has to be a complaint before that committee. And let it be remembered, Steve, that in relation to the bashing of the chef Bejic in the Surfers Paradise police station a couple of years ago,
Yes.
I made a complaint to the Parliamentary Committee saying not only did the police completely wreck their credibility with failing to prosecute the police responsible, the Triple C signed off equally on that appalling decision. And I said to the Parliamentary Committee, what are you going to do about the Triple C's absolute ineptitude in signing off on a decision that the police wouldn't be charged? The committee did nothing. Now, in fairness to the current chair, Alan McSporran QC, that was before his time. So the Parliamentary Committee is not a very effective oversight body at all.
Alan McSporran told ABC News the ultimate test of whether the Crime and Corruption Commission's powers were being used appropriately was whether judges and magistrates allowed its evidence to be used in court despite challenges from defence lawyers. Is that fair enough?
No, it's not fair enough. The reality is this is how it works. If I'm pulled down as a target to the Triple C in one of the Star Chamber hearings, I'm made to answer questions. If then there is a case, then the transcript, if I'm a witness, can and will be used in the prosecution of it. I challenge Mr McSporran to tell us when the last time there was a challenge in a magistrate's court or particularly in the Supreme Court to any of these investigative hearings. There are effectively none. One, because they're incredibly expensive to run against a really well-resourced Triple C. And secondly, the court has only very limited jurisdiction as it currently stands to entertain such a challenge anyway. So for it to be said that magistrates readily accept Triple C evidence is a bit of a cute way of putting things.
So what do you want done about it, Terry O'Gorman? What should be done about it, this extraordinary power?
We want the quadrupling of these Triple C hearings pulled back. We want there to be proper court supervision because the Parliamentary Committee doesn't do an effective job. And we want there to be a review of the law to look at how practical is it. We say it is practical, but how practical is it to go back to the Fitzgerald model of saying to the Triple C, you're going to drag people down in a Star Chamber hearing, no members of the public involved, then get a warrant from a Supreme Court judge and have some accountability in the Supreme Court.
Terry O'Gorman, thanks for your time.
Thanks, Steve.
Terry O'Gorman from the Queensland Council for Civil Liberties. And we did request an interview with Alan McSporran, the Crime and Corruption Commission's head. We were told he's travelling and not available to speak to me this afternoon.
Every day, ABC Radio Brisbane brings you stories from where you live.
Stories from the heart.
Stories from the home. Stories that unite.
Stories that challenge.
Join us this Wednesday.
Some critics say the powers are being overused and go too far.
This is one of Queensland's most secretive rooms. Those called to testify in the so-called Star Chamber have no right to silence. If they refuse to cooperate or lie, they can be jailed.
They're a very powerful tool we use, but we take very seriously the use of them, and we have to convince ourselves that there is a proper basis to use the powers.
Evidence from Triple C hearings helped convict 2 men over the McCulkin murders, a crime that had been unsolved since the 70s. In the Tiali Palmer case, the Triple C trapped her foster family in a lie. Eventually, they gave up the killer, foster father Rick Thorburn. But while there's widespread support for the Star Chamber's use in major investigations, there's also concern the right to silence is being taken away in low-level cases.
There has to be some balance, a balance between police powers, Triple C powers on the one hand and civil liberties on the other.
Over a decade, the number of investigative hearings have quadrupled to more than 340 a year. In 2017, Brisbane YouTuber Pluta leaked top-secret documents detailing problems with Queensland Rail timetables and trains.
Newgen is a huge up.
It's understood he was summoned to the Star Chamber and forced to reveal his source. He's since been charged with allegedly revealing he was called to face a hearing.
It'd be different if you were talking about a terrorist incident, but this was talking about problems within Queensland Rail that needed in the public interest to be disclosed.
People who have access to confidential information are under an obligation of trust not to disclose that without very good reason. If there's, for instance, a belief that they want to blow the whistle, as it were, they should come to us confidentially.
The CCC doesn't release transcripts or recordings of its coercive hearings. In many cases, even telling someone you've been summoned to testify can be an offence. Civil libertarians want the powers reined in, but the CCC insists it's kept in check by the courts and a parliamentary oversight committee. Christian Silva, ABC News.
The attraction